what are the strongest 2 or 3 arguments that you think every single father, every single parent who's being wronged in the family court system need to bring up to their judge?
I think the 2 things, and these are the 2 take-home points. 1, I have a 14th Amendment due process right to 50% parenting time unless you can show I'm endangering my kids. Like, enough said. Enough said. Like, open, closed, beginning, end. Tell me why I don't have a constitutional right to 50% parenting time. Like, show me allegations, credible allegations of child abuse, right? That presumption's rebuttable, right? Am I incarcerated and in danger? Am I convicted of the 5th degree, 4th degree, 3rd degree criminal sexual misconduct? Sure. If any of those things are true, then it's a rebuttable presumption. But absent that, when I walk into court, no, I have 50% parenting time. Thing 1, I think everyone needs to open their mouth and say I have a 14th Amendment due process right to 50% parenting time for my kids. Period. And I think everybody should have a PDF of this brief where they can just roll it out, right? The work's already been done. Second point, the research shows that it's best for the kids. If we care for the kids and the parents have both survived this rebuttable presumption, they're both decent people, there's no endangerment. I mean, I could go through some of the research in terms of depression, less obesity, less alcohol addiction, less dependency on drugs, more independence, more higher income outputs, higher educational outputs, all these social indicators in terms of anxiety and depression. Everything goes up in an equal household. Not to mention, so that's the kids. Not to mention the parents feel better about one another because they're not battling one another and they're not kids. So 1, constitutional. 2, if we're looking out for people's health, right? Let's do joint parenting, equal joint shared parenting.
Yeah, I think dead on. I mean, I think one of the biggest things, and I don't know if Casey's watching tonight, but we've had this conversation with the executive director of the Fathers' Rights Movement. And there's research that shows that a mother who has 50-50 custody is something like 54% more likely to be a 6-figure earner. And mental health scores are higher than a mother who has 75% or more custody. The fathers across the board, if they have 50% custody, their mental health scores are through the roof compared to the dad who has less than 25%. And I think we know the issues with child support. You think about it, you're preventing the mom from making money because you're putting so much parental responsibility on her. And then you're taking, unless the dad's making $200,000 a year, you're essentially driving him into poverty when you give him 25, 12, 0% custody when half of his income is going to child support. You create 2 low-income households. How is that ever going to be in the best interest of the child when we know wealth of a family is a major indicator of academic success, college graduation, and a whole number of things? Yeah.
You mentioned 2 things that I hadn't mentioned. Do we have time to dive into them?
Go for it, dude. We got plenty of time.
Okay. Spousal support. Is it called spousal support in California? Is it alimony?
Yeah, we're spousal support out here.
Spousal support. So in Minnesota, it's referred to as either alimony, spousal support, or spousal maintenance, right? Whatever. Money you pay to the spouse, I think is unconstitutional. The best interest standard, I think, is unconstitutional. I filed a challenge in federal court for spousal maintenance, spousal support, challenging the constitutionality. And here are the reasons, right? Spousal maintenance, spousal support, it's the same reason. Void for vagueness, both of them. Both give the court a list of factors, for the best interest standard. It's 17 factors, 13 factors, whatever, various factors where, again, the judge can just, based on that judge's or that guardian ad litem or that custody evaluator or that parenting consultant, that person, based on what objective standard are they using besides their preferences? They are making scientific or they're making legal their personal preferences based on the way they would go through these factors. That's unconstitutional because it fails void for vagueness. It can't be verified, right? Like a speed limit, you know, because a sign is posted at 60 miles an hour. Here, how can you predict in advance what the court is going to say is in the best interest? And if you can't, there's no notice, therefore there's no due process, therefore it's unconstitutional. And moreover, it's vague, right? These factors can be interpreted by Judge A differently than Judge B. Those same vague factors are in the spousal maintenance statute. Therefore, both should be struck. So now there's 3 constitutional arguments that should be brought to your attorney. 1 is the parenting time statute, 2 is spousal maintenance, and 3 is the best interest standard.